Style. I am a realtor licensed in Maine, New Hampshire, and Massachusetts, and many of my episodes will be real estate focused, but also other things business and lifestyle related. Listen up. I hope. Hey everyone, Erica Bruce here, Lifestyle Listed. Today is Monday, November something or other, November 7th. We had a really beautiful weekend, some really decent weather this weekend that was really awesome. So this episode that we're doing is the Maine contracts series. We did listing agreements, we did, buyer agency. So now we're going to do the purchase and sales agreement. So that'll be a good time today. Let's see. Today's Monday. Let's take a look and see. So let's do some Mindful Monday, okay? Something I'm learning and have to relearn sometimes, quite often, in my daily endeavors, not just in work, but in personal life too, is we don't know that there's more to know sometimes. So offer knowledge and ask questions. Simple as that. So for the Maine purchase and sales agreement, there are other forms that you are going to have ahead of time. You're going to have the buyer's agency agreement, and there we go. And you're going to have brokerage relationship disclosure form. Maine also has arsenic and a residential property transaction booklet. If you're listening, it will be somewhat helpful, but the best way to really absorb this is go ahead and take a look on YouTube for the YouTube video and watch as I review the actual form, live. So it says purchase and sales agreement. Days means business days unless otherwise noted. So that means Monday, Tuesday, Wednesday, Thursday, and Friday, not holidays. And the other thing about this is a purchase and sales agreement for residential. There is another one specifically for just land. The beginning here is going to be offer date. Okay, you're gonna be entering the day that you're submitting the offer. Okay, the effective date is not something you get to fill out ahead of time. The effective date of this is when this is your offer, okay? So if your offer is accepted and signed by all parties, the last receiving party completes the effective date, okay? Parties. Who is this agreement between? It's between the buyer and the seller, and you're going to enter the names here. Full names, full legal names. If it is a entity, you would put the entity name or potentially a trust name. Number 2, description subject to the terms and conditions hereinafter set forth. Following. Seller agrees to sell and the buyer agrees to buy. There's a choice here. All or part of the property situated in the municipality of blank. Municipality is usually a town. Sometimes it is a village. In the county of blank, in the state of Maine, located at, if it's a residence, it will have an address. So we'll be putting the address there. And described in the deeds recorded at said county registry of deeds books blank and blank. Let's talk briefly about the all or part of. If we're choosing part of a property, I don't know if you've ever seen a deed. Sometimes there are multiple parcels on one deed. You would definitely want to indicate that. Okay. This is different than New Hampshire. Number 3 is fixtures. Buyer and seller agree that all fixtures, including but not limited to existing storm windows, the screens, the shades and or blinds, shutters, curtain rods. First of all, guys, sometimes curtains, you can use in a new place, but curtain rods are attached, blinds are attached, shades and window screens are not only attached, but they're specific to that house. It's very unlikely you're going to take them with you and find that they fit perfectly in your new house, right? This is to make sure that these things are coming with the property and the seller's not taking them. Built-in appliances, heating sources and systems, including gas or kerosene, fired heaters, and wood/pellet stoves. Sump pump, electrical fixtures, meaning the light fixtures, hardwired generators, landscaping, and blank are included with the sale. So blank is if there's a fixture that's specific to the home. Maybe there's a movable kitchen island. You can put that here, all right? And then we have the exception. If any of the above you're not conveying, for example, the wood stove is not going with, you would add this here. It would also be helpful to write where the wood stove is located and whatnot. Seller represents that all mechanical components of fixtures will be operational at the time of closing, except. I know that sounds strange. However, if mechanical components are broken, or if potentially it is a seasonal property and everything gets shut down for the winter, it will be noted here. Otherwise, they should be operational at time of closing, which means at the walkthrough, the buyers can go and check it out and see that everything's, properly functioning. Personal property. The following items of personal property as viewed on, and this date is going to be the day you went and looked at the property, are included with the sale at no additional cost, as is conditioned with no warranties. Personal property would be something in the nature of, and you're going to have to excuse me, I have to actually go let my cat in, out. Okay, brief disturbance. You could put not built-in appliances. So like a built-in appliance would be like a wall oven or something of that nature. This would be like range, refrigerator, chest freezer, microwave if it's not built in, etc. Okay. You can even include items that are specific to the house, but are not even appliances. For example, some houses have a bar to eat at, so you could be like kitchen bar stools. Maybe there's a hutch that's basically being used as cabinetry. That stuff could go there. For number 5, we're going to talk about the purchase price and earnest money. For such deed and conveyance, buyer agrees to pay the total purchase price of blank. This is going to be your purchase price, offer price. Okay. So you're going to put that here. We'll put $375,000. Okay. And we talk about the buyer has delivered or will deliver to the agency within blank days of effective date a deposit of earnest money. So, quick explanation. An earnest money deposit is the buyer's stake in the game. It can be refunded to the buyer if the agreement here is terminated per the conditions of the agreement, but could potentially be lost if it is terminated for reasons outside of those named in the contract. Most commonly, we'll put within 5 days of effective date. Keep in mind, and I have to remind myself of this too, Maine is business days. So you have to be more careful about counting the days. It's not just 1, 2, 3, 4. You have to skip the weekends. Deposit of earnest money in the amount of, most commonly, we're kind of putting between 1 and 3% of the purchase price. We definitely want to put enough down that it's something, substantial. So $5,000. Now, this next section is optional. The buyer agrees that additional deposit of earnest money in the amount of, again, there's a blank spot here. You could put another $5,000. Will be delivered blank. In some cases, in larger purchases, you're doing multiple deposits. The great part about this, as opposed to in New Hampshire, is it just says will be delivered blank. There's not a date here. There's not a days from effective date here, although you could put that. Oftentimes, most people will be, after inspection period. I would like to mention that putting actual dates here, the more specific you are and clear, the better. If you're not going to use this, you can fill these in with, NA, not applicable. So if the buyer fails to deliver any of those deposits in compliance, the seller can terminate the agreement. What? Yes. You have to follow all of your agreements in this contract, or the contract then can be voided. The remainder of the purchase price shall be paid by wire, certified cashier's, or trust account check upon delivery of the deed. So it's the purchase and sale agreement is subject to the following conditions. Escrow agent acceptance. Here you're going to be putting the agency. It's going to be either the buyer's agent or the seller's agent, meaning brokerage, here. In my experience in New England, it's very commonly the listing agent, but it doesn't have to be. Our brokerage offers ACH deposit, which is more secure and convenient. So if I reach out and say, hey, does your agency have that? And they say no, I said, okay. So Better Homes and Gardens, Massiello. You're going to hold the earnest money and act as the escrow agent until closing. This offer shall be valid until. Here you can enter a date. Generally giving them 24 hours or more is a good idea. I generally don't like to make an offer expire unless you're truly not willing to continue with the purchase should it go past that timeline. And then even here, it says a time to make it clear. And I would like to know prior to when I put my phone away to go to bed, right? So 5 p.m. Oh, and then we're going to talk about number 7, title and closing. A deed, conveyed good, and merchantable title in accordance with the standards of title adopted by the Maine Bar Association. Those are just the standards of how a deed is written up, and you're welcome to go look at them. It's going to be delivered to the buyer, and then this transaction shall be closed, and the buyer shall pay the balance due and execute all necessary papers on blank closing date or before. On or before, meaning if agreed in writing by both parties, that means you could close before this date if everyone's capable of doing so, as long as everyone's in agreement. So keep that in mind. It is not a hard and fast, we have to close on this date. We need to close by this date. And most commonly, it ends up closing on that date, or in some cases after, which would require an addendum. Just so you guys have a general idea, currently, for any type of purchase that is using lending or a loan from a public provider, we're looking at 45 days. So we need, we want to calculate that out. So if we're sending this, today on November 7th, December 7th is a month, and then maybe another couple of weeks. We want to make sure that this is not a weekend day too. So we want to take a look at the calendar, make sure the date we enter here is appropriate timing. If it's a cash purchase, it could definitely be way sooner than that. Okay. Then it talks about the seller's responsibilities about if they're not able to convey a deed, as mentioned above, they're going to have a time period, not more than 30 calendar days, from when they're notified of the defect, unless otherwise agreed to remedy the title. This seller hereby agrees to make a good faith effort to cure any title defect during such period. And if at a later of the closing date set forth above or the expiration of such reasonable time period, seller is unable to remedy the title, the buyer has the option to close and accept the deed with a title defect, or they can terminate this agreement, in which case all parties shall be relieved of further obligations, and then you get your earnest money deposit back. This way, the buyer is not obligated to purchase the property if there's a defect in the title. If you have questions about defects in titles, I would love to do an episode, on what possible title defects are. The property shall be conveyed by a blank deed and shall be free and clear of all encumbrances except covenants, etc., restrictions on record, which do not materially and adversely affect the continued current use of the property. In New Hampshire, a lot of times we'll put warranty here. Quick claim is also very common. It depends on the state you're in. At the bottom, they have 4 sections for seller initials and buyer initials. They talk about possession. Number 9 is possession, occupancy, and condition. Unless otherwise agreed to, this property is coming, no tenants, no occupants, okay? And is going to be given to the buyer immediately at closing, okay? They need to be broom clean, literally just that. Not scrubbed, broom clean, free of all possessions and debris. This includes the exterior people, the yard, and in substantially the same condition as at present, excepting reasonable wear and tear. And the buyer shall have the right to view the property within 24 hours prior to closing. That is what we call the closing walkthrough. I got to stay hydrated. Number 10 talks about risk of loss, damage, destruction, and insurance. God forbid something happened to the property while it's under contract. We're going to state what's going to happen here. If risk of loss, damage, or destruction of the premise is going to be solely assumed by the seller. They need to keep it insured against fire and other extended casualty risks prior to the closing. And if they're damaged or destroyed prior to the closing, the buyer can either terminate and get a refund of their earnest money, or close the transaction and accept the premises as is with the assignment of the insurance proceeds. That means if it burned to the ground, you could still continue with the purchase and accept the insurance proceeds. That's entirely up to you. It's just so that people don't sellers don't attempt to keep the insurance proceeds and continue with the sale. That wouldn't be right. Number 11 talks about fuel, utilities, and prorations. This makes it very clear. The buyer is either going to or going to not, shall or shall not, pay the seller at closing for all fuel in any tanks remaining on the property. When bidding was, really competitive, we're going to put shall. When it's more of a buyer's market, a lot of times shall not will be checked off there. If it is shall, okay, if they're going to pay the seller at closing for the fuel in the tanks, it's going to be calculated as of the closing date or such earlier date as required to comply, basically that week. The amount owed, if any, shall be determined using the most recently available cash price, and it must be of the company that last delivered the fuel, not the price that the seller paid for it. Most recent available cash price of the company that last delivered the fuel. Metered utilities such as electrical, water, and sewer will be paid through the date of closing by the seller. Through the date of closing. So the seller is responsible for the whole entire date of closing. And then there's other items that could be prorated as of the date of closing. Rent, association fees, other, who knows what could be here. Road maintenance fee, something of that nature. Special assessments, I don't know. And it goes to repeat here to make it clear. The day of closing is counted as a seller day. Okay? So real estate taxes are going to be prorated as the date of closing. The seller is going to be responsible for any unpaid taxes for prior years. That is and should be understood. It is not something that is on the boilerplate offer of a New Hampshire purchase and sales. If the amount of said taxes is not known at time of closing, which is sometimes the case, they're going to be figured out on the basis of taxes assessed for the preceding year, with a reapportionment as soon as the new tax rate and valuation can be ascertained. The buyer and seller will each pay their transfer tax as required by the state of Maine. So, any questions? Most often, the municipality where you're moving is going to work in conjunction with the title company or lawyer that is doing the closing, most commonly a title company, in my experience, to figure out the potential tax that is going to be prorated. Due diligence. The seller or the licensee, meaning the people that are selling the property and the owner of the property, they're not making any warranties about the condition, permitted use, okay, or value of real or personal property, or if it's compliant with any federal, state, or municipal codes, including but not limited to fire, life safety, electrical, and plumbing. Buyer is encouraged to seek information from professionals regarding any specific issue or concern. So what that is saying is all of these items are up to the buyer to do their due diligence to make sure that the permitted use of this property is what they're looking for it to be. That could include being in an HOA, having a pet, raising chickens. Okay. Also, it's their responsibility to make sure that any additions or any building has been permitted, and when permitted was agreed by the town. And then it says the obligation to close is not subject to any due diligence investigations. Buyers are relying completely on their own opinion as to the condition of the property, or the buyer's obligation to close under this agreement is subject to their satisfaction with the results of any due diligence investigations undertaken. Buyers shall have blank days from the effective date to perform these due diligence investigations as the buyer deems necessary, which may include but are not limited to any or all of the following. So this is a little bit different. And the reason why I keep mentioning New Hampshire is because it is quite often the case that people are looking both in New Hampshire and Maine, or both in whichever state and whatever state, where they abut. Keep in mind when you put so many days from effective date, we're talking calendar days. And then it goes on to list all of the, possible items. So general building, that would be like a general building inspection. The sewage disposal, that would be, reviewing to make sure the sewage disposal is working or current or up to code. Water quality, that would be like a water test if it's in a well. Water quantity, it's like a gallons per minute type of thing. Air quality, square footage, code conformance, registered farmland, environmental scans, smoke or CO detectors, zoning, pests, pool, insurance, mold, survey, lead paint, floodplain, chimney, tax status, habitat review, waterfowl, shoreland, septic, energy audit, lot size, acreage, arsenic, wood, and water. So any of these investigations that the buyer chooses to do is going to be expense of the buyer, okay? And they're going to be done by the persons chosen by the buyer in their own discretion. The seller is agreeing to cooperate with the buyer, and they're going to give the buyer and the buyer's agents and consultants reasonable access to the property and its systems, fixtures, and whatnot to undertake the investigations. The buyer agrees to take reasonable steps to return the property to its pre-inspection condition. That being said, an inspection should not destroy any of the property, okay? If the buyer finds that any part of this investigation is unsatisfactory, they can terminate the agreement as long as they notify the seller in writing within the specified number of days up above, and they'll get their earnest money deposit back. If they wish to, they can also pursue remedies other than voiding the agreement. But they must do so to full resolution within the time period set forth above. Otherwise, this contingency is waived. So keep in mind with the date above, it is not just when you're getting these done by. It is not when you're notifying the seller that you want a resolution. This timeline is actually when you must fully come to full resolution, okay? If the buyer doesn't notify the seller that it's unsatisfactory, or if any investigation under this paragraph is not performed or completed, this contingency and the right to conduct an investigation are waived by the buyer. So basically, if you're not having an inspection on these items, then you're waiving that particular item. A lot of people aren't going to do an air quality check unless there's a concern for it. Some people are not going to be concerned with the floodplain or lead paint because of the age of the home, or that it's not on a floodplain. Pool, you're not going to check out the pool if there's no pool. Basically, if you don't say anything to the seller by the timeline as mentioned above, we're all considering that you're good with it all. Move to the next step, okay? If this property is enrolled in the Maine Tree Growth Tax Program, the seller agrees to provide the buyer with the current forest management and harvest plan with blank amount of days. This is only going to apply if it is in the Maine Tree Growth Tax Program, and then you'll put a number of days. Number 13, a property disclosure form. The buyer is saying, hey, I've got the property disclosure form, and the information developed by the Maine Center for Disease Control and Prevention regarding arsenic in private water supplies and arsenic in treated wood. Yes, I talked about those in the opening statement. These are information, but they're also disclosures to the public about these particular areas of concern. Number 14 is financing, okay? A lot of properties are subject to financing. It gives us two options. If it's not subject to financing, here's your options. It's not subject to financing. The buyers provided the seller with acceptable proof of funds. Or it's not subject to financing and we're going to provide you with a proof of funds acceptable to the seller within blank days. If the seller finds it not acceptable, they can terminate the agreement no later than blank days from receipt. And if the proof of funds is not provided, the seller can terminate the agreement, which right shall end once such proof is received. However, seller retains the agreement upon time period to terminate if such proof is unacceptable. In either case, if the seller terminates, the earnest money shall be returned to the buyer. In this market, in any market, let's just provide the acceptable proof of funds to the seller, okay? If it's not subject to. And then an example of that could be many things. We like to share examples that are the least intrusive on the buyer's personal information, personal finances, where they hold their money, all kinds of things. It could be something as simple as a statement of an account. If available, a letter from one of the institutions that holds your funds is great, because then it just says so-and-so is able to purchase the property, has the funds to purchase this property at, whatever price. And then it may not be subject to financing, but we also want to know the buyer's ability to purchase is or is not subject to the sale of another property. No matter which one it is, we want to be is not, okay? Or is. We want to make sure we choose one or the other. And then if there is one, there's a particular addendum for that. On the other hand, most commonly, you're going to not check any of these. Okay, so you're either going to be keeping either section of this blank, basically, section 14. If it is subject to financing, it is as follows, okay? It's subject to them obtaining a blank loan. It could be conventional, it could be FHA, it could be VA, it could be portfolio. There's different kinds of loans. You can put the type here. A blank percent of the purchase price. We'll just put like 85 because that's, kind of common. And what that means is the lender is paying 85% of the purchase price, okay? And most commonly, this will be on their pre-approval. At an interest rate not to exceed blank. So this is different than the New Hampshire Purchase and Sales Agreement, which has a blank here, and a lot of people put prevailing. Reach out to your buyer's lender and say, hey, what interest rate can my buyer still afford the property? That's an answer. Maybe it's 14. Oof, that's a lot. Talk to the buyer. Say, hey, what do they want their payments to be? What is interest rate is reasonable here? So depending what the interest rate is now, you're probably going to put a little bit above that. Talk to the lender. And amortized over a period of, most commonly, this is going to be 30 years. It could be 15. It could be whatever, depending. The buyer has a good faith obligation to seek and obtain financing on these terms. Insert, the buyer should have already done so in current market terms. If such financing is not available to the buyer as of the closing date, the buyer is not able to close and may terminate this agreement, in which case the earnest money shall be returned to the buyer. So this particular information up here is very specific. If any of this changes, we want to make sure we update it, because the buyer's obligation to close is contingent upon the financing mentioned above, okay? The buyer is going to provide the seller with a letter from the lender showing they've made an application for loan, subject to verification of information, is qualified for the loan within so many days of the effective date. Let's just say 3. Basically what happens is, for us, once this is effective, meaning we're under contract, one of the first things we do is we forward this and any addenda to the lender that has already pre-approved the buyer. So it should be easy to do, okay? If the buyer fails to provide the seller with a letter that they've done so, the seller can actually terminate the agreement. The buyer does get their earnest money back. And once the letter, the right to terminate ends once the buyer's letter is received. 14C is really important. The buyer authorizes, instructs, and directs its lender to communicate the status of their loan application to the seller, seller's licensee, and buyer's licensee. Meaning, once you put this offer in and it's they're saying that the lender can communicate with the seller, the seller licensee, about the status of the loan, okay? I don't know about you, but if I have a listing, I'm going to be communicating with the buyer's offer, the lender's pre-approval that they send over. After B is met, meaning the loan application deadline there, If the lender says, hey, you're not able or unwilling to provide said financing, the buyer has to provide the seller with that actual written documentation of the loan denial within 2 days of receipt. So if you receive a loan denial letter, you have to forward it to the seller within 2 days. You do have the option to apply with another lender. And then so they go on to say, you can have so many days to provide the seller with a letter from another lender showing the buyer made application. If this lender, for example, has the credit scores they're looking for are a little higher than another lender, this should be doable within 3 business days for them to supply. And if they don't supply that with that, then the seller can terminate. And again, earnest money shall be returned to the buyer. This E talks about financing and specifically the buyer points. Okay. Buyer agrees to pay no more than X points. Seller agrees to pay up to blank towards the buyer's prepaid points and their closing costs, but no more than allowable by the buyer's lender. This is specific money back to the buyer towards, prepaid or whatnot. We can say no more than 3 points. I mean, to pay a point is 1% of the purchase price. So, and then this is basically the buyer saying, hey, seller, I'd like you to pay so much money back to me at closing. This helps with people who have less cash in hand. And so the seller would be paying that back out of the whole purchase price, basically. If it doesn't apply, if you're not asking for it back, you can just say NA or cross it out. And then F, again, their ability to finance is or is not subject to the sale of another property. Meaning, do they have to sell the property they own to get the funds to purchase this one? G, hey, the buyer can choose to pay cash instead of obtaining financing. If so, the buyer shall notify seller in writing, including providing proof of funds, and the agreement shall no longer be subject to financing. And the seller's right to terminate pursuant to the provisions of this paragraph shall be void. And the seller's obligations pursuant to 14E shall remain in full force and effect. Basically, if the seller has the option to purchase with cash and they decide they're not going to use financing, they can do so. But they have to notify the seller in writing, include proof of funds, obviously. And then anything subject to financing up above is no longer applies, okay? Brokerage disclosure. Hey, we have received our brokerage relationship disclosure form, and these are the following relationships, okay? So the licensee, which will be the agent representing you, so it would be like Erica Bruce. MLS ID. I don't know my MLS ID off the top of my head for Maine. From the agency Better Homes and Gardens, and their MLS ID is representing the buyer, let's say. And of course, your buyer's agent is going to be filling this out for you, but it's nice for me to have so I can present this to my buyers and so they can, watch it in real time whenever they choose. Then you're also going to be putting, the listing broker, okay, the listing agent. So, and they're either going to be seller agent. It also gives you the option for disclosed dual agent or transaction broker. I have not encountered a transaction broker yet. The agency that they are with, okay? If it involves disclosed dual agency, the buyer and seller acknowledge the limited fiduciary duties of the agents, and they're consenting to this particular arrangement. The buyer and seller also acknowledge prior to receipt and signing of disclosed dual agency consent agreement. So in order for disclosed dual agency to occur, you also have to agree and sign the disclosed dual agency consent agreement. You cannot have disclosed dual agent relationship if one or both parties disagree. Both parties have to be in agreement, okay? Number 16, default or return of earnest money. If the buyer doesn't fulfill their obligations here under, it constitutes a default, and the seller may employ all legal and equitable remedies, including, without limitation, well, termination of this agreement, okay, and forfeiture by buyer of the earnest money. Seller's failure to fulfill any of the seller's obligations shall constitute in default, and the buyer may employ the same, okay, and terminate the agreement and return the buyer's earnest money. The agency acting as escrow agent, which is one of the forms above, has the option to require written releases from both parties prior to dispersing the earnest money to either party. In the event that the agency is made a party to a lawsuit by virtue of acting as escrow agent, they're entitled to recover reasonable attorney fees and costs, which shall be assessed as court's cost in favor of the prevailing party. There is a separate form for release of escrow, and it says, how much and who the recipient is of escrow. Okay. It talks about mediation, earnest money, or other disputes within the jurisdictional limit of small claims court will be handled in that forum, mediation. All other ones arising out of relating to this agreement or the property should be submitted to mediation in accordance with the generally accepted practices. Buyer and seller are bound to mediate in good faith and to each pay half of the mediation fees. If a party fails to submit a dispute or claim to mediation prior to initial litigation, then the party will be liable for the other party's legal fees in any subsequent litigation regarding the same matter in which the party who failed to first submit the dispute or claim. So, this clause shall survive the closing of the transaction. That's put there because any particular disputes sometimes could occur after closing. Maybe the buyer finds out that seller was untruthful about their disclosure on the property, something of that nature. This is a lot of legal wording, and we always suggest that you as buyers or sellers, if you need further explanation other than what it reads here, please reach out to an attorney. Specifically, I would suggest one that functions in real estate. Prior statements. Hey guys, anything you talked about, if it's not written here, it's not the case, okay? It further goes on to say, any changes to this have to be agreed by both parties and must be written and signed off on by both parties. So keep that in mind when you're putting in your offer. You can't just change things or decide, for example, the type of lending. You have to make sure that the seller's okay, that you're changing the type of loan. You'll have to sign off on it. Heirs and assigns. This is going to extend to be obligatory upon heirs, personal representatives, successors, etc., of the seller and the assigns of the buyer. This is, so imagine you're under contract with someone and the seller unexpectedly passes away. This is going to be extended to their heirs. Counterparts. This agreement may be signed on any number of identical counterparts with the same binding effect as if the signatures were on one instrument. Original or faxed or other electronically transmitted signatures are binding. So what this is saying is, like, say the seller gets this on paper, all right, and the seller signs it, and the buyer gets this on another paper and the buyer signs it. As long as they're identical, it will be considered one complete document. Since we do have electronically transmitted signatures, this really shouldn't occur, but you never know, okay? Number 21, shoreland zone septic system. This is talking about, hey, does my septic system, is it in the shoreland zone? And you just say yes or no. If it is, the seller has to provide certification at closing indicating whether the system has or has not malfunctioned within 180 calendar days prior to closing. It's always better to get this ready ahead of time. Any notice, number 22, notice, okay? This is talking about communication or document delivery. They may be satisfied by providing the required notice, communication, or documentation to or from the parties or their licensee. Meaning, me as an agent, as a licensee, if I'm providing it on behalf of the buyer, it's considered from the buyer, okay? Only withdrawals of offers and withdrawals of counteroffers will be effective upon communication verbally or in writing, meaning it's effective the minute you send it. It doesn't have to be read. Effective date, business days. This talks about what effective date really means. It's binding when the last party signing has caused a paper or electronic copy of the fully executed agreement to be delivered to the other party, which shall be the effective date. The licensee is authorized to fill in that on page 1. Except as expressly set forth to the contrary, meaning like if you were to write in something, the use of the term days in this agreement, including all addenda, it means business days, defining as excluding Saturday, Sundays, and any observed Maine, state, or federal holidays. So you better get your Maine, state / federal holiday calendar out. Deadlines, including all addenda, expressed as blank days, we're counting those from the effective date, unless another starting date is expressly set forth. Beginning with the first day after the effective date, or such other established starting date, and ending at 5 p.m. Eastern time on the last day counted, unless expressly stated. Everything on the date ends at 5 p.m. Woohoo! Which means you don't have to be keeping to check your emails or contact information after 5 p.m. This is great. It's great. So 1 day from the effective date is the day after the effective date. Just so you know. Confidentiality. The buyer and seller are authorizing the disclosure of information here to real estate licensees, attorneys, lenders, appraisers, inspectors, investigators, and others involved in the transaction, this particular transaction, necessary for the purpose of closing this transaction. The buyer and seller authorize a lender or closing agent to prepare the documents or settlement statement to release a copy of those to the parties and their licensees prior to, at, and after closing. This is great. Yes, please send me those things. This way we don't have to, ask the buyer, oh, can I send that to your agent? Addenda. Is there addenda? Are we adding more other conditions that don't fit in here? There are plenty others that could be attached. For example, the home sale contingency, seller suitable housing, that sort of stuff. There's a few common ones here. Lead paint, yes or no. That it would probably be not relevant after 1978. Other, yes or no, and then I'll have a brief explanation. Other conditions. Here's a brief spot where you can add other conditions to this particular offer. And then it goes over the general provisions. Copy of this agreement is to be received by all parties. Yay! And by signature, receipt of a copy is hereby acknowledged. If not fully understood, contact an attorney, as I said before. This is a Maine, M-A-I-N-E, contract and shall be construed according to the laws of Maine. So any review or whatever from an attorney needs to be done through the laws of Maine. The seller acknowledges that the state of Maine law requires buyers of property owned by non-resident sellers to withhold a prepayment of capital gains tax unless a waiver has been obtained. This would be like if a Massachusetts seller had a vacation property or a second home in Maine, that there's going to be a withholding of prepayment of capital gains tax. Okay. Buyer and seller acknowledge that under the Maine law, okay, payment of property taxes is the legal responsibility of the person who owns the property on April 1st, even if the property is sold before payment is due. If any part of the taxes is not paid when due, the lien will be filed in the name of the owner as of April 1st, April Fool's Day, which could have a negative impact on their credit rating. Buyer and seller shall agree at closing on their respective obligations regarding actual payments of taxes after closing. Buyer and seller should make sure they understand their obligations agreed to at closing and what happens if taxes are not paid as agreed. AKA back to, the first point, contact an attorney. The buyer acknowledges that the Maine law requires continuing interest in the property and any backup offers to be communicated by the listing agent to the seller. We're just notifying you, buyer, that backup offers can still be received even though you're under contract. And obviously, they're going to be, the listing agent's going to tell the seller about them. Basically, the detail of such is none of your business. It may be in the interest of the listing agent to tell the current buyer we have a backup offer. A backup offer, in case you didn't know, is exactly what it sounds like. It is an offer that is agreed to be taken as the very first backup. If your current contract is for whatever reason voided, then the backup offer automatically becomes under contract. If, whenever this agreement provides for earnest money to be returned or released, the agency acting as escrow agent must comply with the Maine Real Estate Commission rules, which may require written notices or obtaining written releases from both parties. Buyer initials, seller initials. Also, they're saying electronic signatures. Anything here, and including all addenda, we're all agreeing that either party may sign electronically. All right. The buyer's mailing address is blank, and then the buyer signs. The seller accepts the offer and agrees to deliver the above described property at the price and upon the terms and conditions set forth, and agrees to pay agency a commission for services as specified in the listing agreement. The seller's mailing address is blank. Seller signs. Or the seller has the option to counteroffer here in this form. Seller agrees to sell on the terms and conditions as detailed herein with the following changes or conditions. So the seller could respond in this section here and say, this contract is not contingent upon the buyer's sale of property located at whatever. Okay. The parties acknowledge that until signed by the buyer, the seller's signature constitute only an offer to sell and will expire unless accepted by the buyer's signature with communication of such signature to seller by date and time. This is great. You know why this is great? Because this allows the listing agent to draft the offer to the buyer after discussion and says, hey, this is only good for this long. Okay. So we're going to have seller signatures, seller signature, and then the buyer would sign here only if the counter offer was accepted. At the very end, it has extension. This is a closing date extension. This means that if you need to extend the closing date, you wouldn't have to complete a separate addendum, which is something that you have to do in New Hampshire. And it's just going to say the closing date of this agreement is extended until blank. And you fill in the new date here, and then everyone signs it. And that's it. That is the purchase and sales agreement for Maine residential property. Let's see. I hope to cover with you coming soon Massachusetts documents. I am licensed in Massachusetts and have had contracts class training. However, I have not had the opportunity to complete transactions in Massachusetts. But it will help to illustrate to you what is involved in completing the forms and developing the relationships and submitting contracts. So, guys, before buying or looking, contact a lender. Please see my resource page, lifestyle-listed.com resources. There's also discounts there. You can get discounts with hotels, all kinds of neat little nifty things and resources for you. You need to find a title company. There's a few there that I've worked with previously. There's a button to click to get a quote. Check out my resource page. Please like, subscribe, share with a friend or family member you know that may be purchasing soon in Maine. I hope to hear from you all soon. Have a great day.